Thank you very much. I hope they warned you I would be speaking in English, and thank you for allowing me to. I moved to Europe 19 years ago, and I hear a lot of Norwegian on one of my favorite TV shows, but I haven't picked up enough to give the speech. I'm glad to be following Christine, the previous speaker. I've spent a number of years since we started selling cloud services in Europe on government policy issues influencing the use of cloud. But over the last couple of years, spending more and more time on the issue of law enforcement access to data in the cloud. I'll be speaking to you about the why, some of our perspective, why we are in these lawsuits, the status of the current suit, and then some thoughts about the future. Now, you mentioned one case. I'm actually going to speak a little bit about three cases. Two of them involve disputes with the US government, and one involves cooperation. The first case I want to mention is when we and other companies in the industry sued the US just over transparency of surveillance requests, just allowing us to speak more publicly about what was happening. Second lawsuit is the one you mentioned, regarding Microsoft's refusal to comply with a warrant for data stored in Ireland. The third case, however, offers a little bit of a contrast. The day after the Charlie Hebdo attacks, we received a demand for customer email data from the French government via the FBI. The data was actually stored in Ireland, and we delivered that data within 45 minutes. The consistency among these cases is that our response depends upon clarity of legal process. We always want to support law enforcement. These cases, our disputes are not about trying to obstruct enforcement or give safe haven to criminals, but we need to act within defined bounds, as does law enforcement. Let me step back a minute just to say, this is our CEO, Satya Nadella. We are a technology company that's very passionate about the amazing things that technology can do for society. We also recognize or understand or are cautious about misuse of technology. And further, we recognize the expectations that we, like everybody, need to help preserve the timeless values that transcend technology. And I'm talking about individual rights, whether it's privacy or freedom of expression, as well as collective interests, like democracy and public order. Now, people will use technology and get more benefit from it if they can trust it. And the cornerstone of trust has been shaken in the last couple of years. As we've moved to cloud computing services, we are asking customers to trust us more than they have in the past. We're not just selling software as a productivity tool or for connectivity. We're actually storing and holding customer data, which can amount to their most important information assets. The data belongs to our customers and not to us. We're also in an environment, as you know, where we see swinging public attention from high concern with security to high concern with privacy, and sometimes back again to high concern with security. Now, it's natural for all of us to be swayed by crises and immediate priorities. At the same time, we should strive for a rule of law that is more steady and that reflects values that endure. As written private communications moved from letters to email and to digital content, there has been the need to change some of the laws so that law enforcement can get access to evidence, but still do so within agreed constraints. Now, our case tests the bounds of the current law, especially as we all try to cope with how do the rules related to physical evidence that we're accustomed to apply to digital evidence. We've learned, for example, through this survey, that most people expect the privacy protections that apply to letters and written documents also to apply equally to email content. The backdrop, of course, to a lot of the current discussions is the Snowden revelations. Now, whatever any of us think about his actions, it's fair to say that he set off a significant debate about government surveillance, about technology, and about personal privacy. Now, he exposed a lot of programs, a lot of facts, but the revelations also created a lot of misperceptions, misimpressions that we as a business needed to deal with as our customers were asking us, Microsoft, what are you doing? Now, I'm speaking specifically of three misimpressions from the revelations. One was that somehow the government had direct access to our systems through some sort of backdoor. Two, that millions of our customers were affected. And three, that we were acting voluntarily to hand over data to the government, regardless of legal process. Now, to address these misimpressions, we started with some efforts to promote transparency. First, regarding data demands. Unfortunately, the US government would not allow us even to give basic information about the FISA law and the requirements to turn over data, or about the number, even the total number of demands, national security orders. So we had to file a lawsuit in order to get that permission to give even basic information to our customers. Now, the US government did make concessions in that lawsuit. As a result, we now have a transparency report relating to national security orders, as well as law enforcement requests. And you can see that over a 6-month period, just to give an idea of the scale of the issue in national security orders, over a 6-month period, there were fewer than 1,000 orders and fewer than 19,000 customer accounts involved. Now, that's a very tiny fraction of the hundreds of millions of customers we have. Regarding transparency about our own software code, we extended a program that already exists to help governments in Europe and elsewhere to examine, to inspect our code, to ensure for themselves that there aren't backdoors. And I've been at Microsoft long enough, actually 17 years, to have seen repeated efforts over the years by competitors to try and scare customers into thinking there was some dangerous backdoor in Microsoft software. That's not how we can run a business. And now the Norwegian government and other governments can inspect the code to verify that. There were other revelations, too, including interception of data traffic that we knew nothing about. Now, there was no evidence that our customers' data was involved. We wanted to take steps to protect our customers, and so we enhanced our encryption of all services. We also did something that nobody else in the industry did. We gave a promise to our enterprise customers that we would litigate on their behalf if any government demanded data, their data from us without first going to the enterprise customer. Now, in fact, we get very, very, very few law enforcement requests for enterprise data, and we do refer those to the owner of the data. By far, most law enforcement requests involve individual criminal suspects. And we understand that, of course, there are investigations that involve the need to access data without going to the suspect, of course, but it still needs to be done with proper legal authority. We received this warrant in late 2013 from a New York court. It was seeking all of the emails from a certain customer of our Outlook.com service. The underlying case involved drug trafficking and other crimes, so it was not national security related. When we looked at the warrant and then we looked at the customer account, we discovered that the customer's data was not in the United States. The customer's data was in Ireland, outside the US territory. Now, this is common now for our European customers for their data to be stored in Europe. This has only been since the last 5 years or so, since we were expanding data centers. But this is, again, outside US territory, and in fact, in a specific place, in this data center outside Dublin, a physical place. Now, it's important to remember that a search warrant is a court-approved license to trespass, to break and enter, to take evidence from a location, property from a location. It's not to be treated lightly. Now, it doesn't make sense for the FBI to send an agent over to our Dublin data center to force entry to Microsoft's building and get that customer's property. It does make sense for the US to seek cooperation of the Irish authorities for law enforcement efforts in Irish territory. Now, in this case, the government, and that's what MLATs are for, mutual legal assistance treaties, right? Well, in this case, the United States argued they did not need to go through the MLAT process, that they could get the data anywhere in the world, and that we should help them seize it, regardless of any potential conflicts with local law. Now, Ireland is a sovereign territory with its own laws. It's interested in law enforcement activities in its territory. It's a friendly country with the US. It has a working MLAT. We honestly believe that if the US used the MLAT process in this case, it would get what it needed and would not need to circumvent that agreed process. Now, to explain a little more, our view is that the warrant in this case is based on a law, a US law, the Electronic Communications Privacy Act, that is not clearly extraterritorial in nature. Therefore, it provides authority within the borders of the US. There's no automatic extension of that authority outside the US. The US, on the other hand, views the warrant a bit like a subpoena for business records. And business records can force companies to bring in business records from around the world in response to a subpoena. Now, a very important element of our case, of our argument, is that what's involved here, the data involved here, email content, belongs to somebody else. It is not business records, Microsoft's business records. Microsoft has business records about the account, such as traffic data, but the contents of the email are like the contents of a letter. That is not ours to give as a business record. Now, as mentioned, the lower court has decided against Microsoft. We've appealed to what's called the Second Circuit Court of Appeals. We've found broad and deep support from different political parties, from different industries, from computer scientists and civil society, and from the Republic of Ireland, and members of the European Parliament. Now, by filing amicus briefs in the court, all these stakeholders are effectively becoming parties to the litigation so that they can make their perspective heard by the court. And they all have some different reasons why they think the warrant is invalid, but all of them agree that proper legal process matters, that ownership and location of data matters, and that international cooperation matters. Now, the appeals court process is not rapid. The oral hearing hasn't even been scheduled yet. We probably won't get a decision till later this calendar year. After that, either party could appeal to the Supreme Court, and it could take another year. And it's an important case. It will establish an important principle about extraterritorial jurisdiction from a US law perspective. But from my perspective, that's only part of the solution, because international cooperation is multilateral. It needs to be decided among nations how some of these procedures need to work, how digital evidence needs to be treated, how to preserve privacy in the context of trans-border access to data. I mentioned 3 cases. The Charlie Hebdo case involved a demand for customer account email contents, but under a law that by its term clearly gives authority to the government to seek data in emergency circumstances. We did what we always do. We examined the order for legal authority. We verified it, got the data, and delivered it in 45 minutes. Now, we and law enforcement, when we follow agreed procedures, we can accomplish what we need to do. Now, for the future, the Dublin Data Center case will run its course, or it may be actually superseded by legal developments. There are proposals in the US Congress to modify the current law, to clarify circumstances when MLAT procedures need to be followed and when they don't need to be followed. But again, that would be in accordance with US law. And that it's encouraging to get that clarity, but still I see there needs to be more international discussion of those very issues and more understanding collectively of when MLAT procedures are adequate, when they're not, and if they're not, how to improve them or use some other process. The bottom line is we all need governments to act to clarify these processes. And when we have a clear and understood legal framework, we feel that our customers will feel more confident and more comfortable with what we're doing and restore trust in the process. Thank you very much.